Yes, Honourable Attorney General.
Madam Speaker, I move that the Certificate of Character Bill number 2 of 2026 be read a second time. Let me start by saying this, Madam Speaker. I make no apology for what will be a lengthier than usual intervention in support of this bill. The Certificate of Character Bill is yet another piece of the puzzle we are building for the benefit of the people. One may wonder what this bill has to do with the rule of law or access to justice for that matter. But then it would be missing the point, which is that this bill is in fact a liberating piece of legislation. It is a necessary step to promote social reintegration for persons who have had a brush with the law and who continue to carry the stigma of a criminal conviction, which always weighs heavily on the convicted person, whether with regards to his entrenched right to work, his right to free movement, and of course, one must never forget the indirect effect on his family. Before turning to the details of this bill, it is useful to begin with two simple, benign questions. First, what is a certificate of character? And second, why does it matter? A certificate of character, or a certificat de caractère, is an official document issued by the Director of Public Prosecutions certifying whether a person has a criminal record. It is still often referred to as certificat de moralité, or even in common parlance, we hear that a person peut attendre gain sa moralité. He or she is waiting for that valuable document, although a literal translation from the Creole might lead to another concept altogether. This certificate, by whatever name called, is nowadays almost always required for employment, for further studies, for visa and immigration procedures, and for a range of other official purposes. For many people, therefore, it is not an abstract legal document. It is the paper that stands between them and a job, a seat at university, the possibility of traveling abroad, or the possibility of a new start in their lives. That is why this bill matters and why it has been eagerly awaited. Madam Speaker, prior to 2006, there was no legislative framework governing so-called certificates of character. These were issued under an administrative practice which had developed over time. In 2006, the Certificate of Morality Act provided for the first time a basic statutory framework. That act introduced, subject to certain exceptions, a cut-off period of 10 years in relation to crimes and misdemeanors. It also provided that a person who had been granted a free pardon under Section 75 of the Constitution would be deemed never to have been convicted of the relevant offence. But the Act, for example, made no provision for the Director of Public Prosecutions to delegate his powers. In 2012, the Certificate of Character Act repealed the earlier law and introduced a number of changes. The title was changed from Certificate of Morality to Certificate of Character, and rightly so, because the law should not pretend that it is the universal judge of morality. The law deals in legal consequences, and it should do so with clarity and restraint. The 2012 Act reduced the cut-off period applicable for certain less serious offences from 10 to 5 years. It allowed the Director of Public Prosecutions to delegate his powers to the Commissioner of Police or another officer. It extended the categories of persons who are deemed never to have been convicted. It also introduced a 3-month limitation period for repeat applications subject to certain conditions in order to reduce unnecessary administrative burden. Those changes were essential and useful then, but with hindsight, they did not go far enough. Madam Speaker, the present law, the 2012 legislation, has remained in important respects unduly harsh. It has caused real hardship to people convicted of less serious offences, because convictions have continued to appear in their certificates in circumstances where that disclosure serves little public good but causes lasting private damage. People have been denied jobs. People have been denied access to university. People who had paid their debt to society have found that society was still presenting them with a bill. That is not good policy. It is not very wise, and in many cases, it is just not just. A criminal sentence, Madam Speaker, is imposed by a court according to law, but once that sentence has been served, the punishment has been meted out. A second, social punishment is not helpful. Justice is not served if a minor mistake becomes, in practice, a lifelong civil disability. Madam Speaker, the rule of law is not only about sanction. It is also about proportion, fairness, and the conditions of reintegration. A society is made safer, not more dangerous, when people who have offended and who have done what the law required of them to pay their dues are given a fair opportunity to work, to study, to support a family, and to live as citizens rather than permanent suspects. I put the question fair and square, Madam Speaker. How shall we prevent reoffending if we tell someone that there is no path for him to lead a reformed life? Rehabilitation, Madam Speaker, is not softness. It is social intelligence. It is also basic justice. This is why the Honourable Prime Minister promised earlier in our mandate that the current law would be changed, and we are today honouring that promise. This bill, therefore, repeals the existing 2012 Act and replaces it with a more just, more coherent, and more humane framework. Its object is clear: to reduce unnecessary barriers to employment, social reintegrations for persons convicted of offences, whilst preserving proper safeguards for the protection of society. In other words, it seeks the right balance between second chances and public safety. One of the problems with the present law is that certain convictions may continue to appear in a certificate for life, even where in any meaningful sense they should be treated as spent. That defeats the very idea of a spent conviction. Now, if the law recognized that after a certain period of time, and subject to certain conditions, a person should be allowed to move on, then the certificate should reflect that reality. Clause 5 of the bill addresses that issue. It provides that no conviction will appear in a person's certificate of character where that person has been granted a free pardon, has been discharged absolutely or conditionally, or falls within the categories set out in that clause, subject, of course, to the exceptions for serious offences provided for in the first schedule. Thus, subject to that caveat, a conviction will no longer appear where either the person has been given only a fine not exceeding 50,000 rupees instead of the current threshold of 5,000 rupees, and 2 years instead of 5 years have elapsed since the date of conviction. Or, secondly, the person has, whether or not he has also been fined, been sentenced to imprisonment for a term not exceeding 5 years, and 10 years have lapsed since the date of that conviction. And thirdly, the offence was committed whilst the person was still under the age of 18. That last provision is particularly important. a civilized legal system does not deny that young people make mistakes, but neither should it decide that a mistake made in youth must follow a person forever into adulthood. If we speak seriously about children, reform, and the possibility of redemption, then the law must speak seriously too. However, Madam Speaker, it is important to stress here that these new parameters will not apply to those serious offences listed in the first schedule to the bill. Convictions listed there will continue to appear on the certificate of character indefinitely. This bill, Madam Speaker, also addresses discrimination in employment. Clause 4 provides that where a person's certificate of character specifies that he has been convicted of a crime or misdemeanor, his employer shall not discriminate against him where that offence is unrelated to the nature of his employment, and a prospective employer shall not discriminate against him where that offence is unrelated to the employment for which he is being considered. That is obviously a sensible provision. A criminal record is not a magic answer to every employment question. Relevance matters, context matters, not every past offence bears on every future occupation. To say otherwise is simply to replace judgment with reflex. Clause 12, Madam Speaker, makes the necessary consequential amendment to the Equal Opportunities Act so that this protection is clearly reflected there as well. It provides that no employer or prospective employer shall discriminate against another person where that person's certificate of character specifies a conviction which is not related to his employment or to the employment for which he is being considered. And here may I add for good measure that the chairperson of the Equal Opportunities Commission was consulted in relation to that amendment. Clause 7, Madam Speaker, deals with the mode of application for a certificate of character. It also provides for regulations to be made by the Attorney General in consultation with the Director of Public Prosecutions in relation to matters connected with the application process. That is entirely proper, the mode of application being essentially administrative. It must be workable, efficient, and capable of adjustment when practical experience shows that improvement is needed. Not every administrative detail belongs to the body of an act. Now let me turn to the first schedule of the bill, which lists the serious offences which will continue to appear on a certificate of character. Generally, there has been a policy decision, Madam Speaker, by the government to keep certain offences on the first schedule and consequently on certificates for life. These are serious offences such as offences against children, aggravated assaults, murders, terrorism, trafficking in persons, murder, manslaughter, rape, dangerous drug offences, etc. However, this schedule has been revised for three principal reasons. First, the current schedule refers to several provisions of the law which have already been repealed. To that extent, it is outdated. Secondly, a number of serious offences which plainly ought to appear in a certificate of character are not presently included. Thirdly, and importantly, the current schedule is not user-friendly. It often refers only to sections of enactments without indicating in ordinary language the offences to which those sections relate. The new first schedule corrects those defects. It no longer refers to repealed laws. It broadens the list of serious offences where this is necessary for the protection of society. And it adds in a third column a description of the offence concerned so that the schedule can be understood not only by lawyers with a statute book open in front of them, but by ordinary citizens reading the law as it should be read, plainly. Madam Speaker, the list of serious offences has been revised as follows. Clause 9 of this very bill, which criminalises tampering with, forging or fraudulently altering a certificate of character, has been included. Secondly, the Child Protection Act, with its corresponding sections, has been removed, given that this Act has since 2020 been repealed by the Children's Act of that same year. Accordingly, a number of provisions under the Children's Act 2020, which had not been included when that Act came into operation 6 years ago, have now been included, thereby plugging a significant gap. Thirdly, previously, all offences under the Dangerous Drugs Act were considered to be serious offences, and any offence under that Act had to remain on the certificate of character for life. Even a small fine of 5,000 rupees for possession of a very small amount of gandia for personal use or for smoking gandia would remain on the certificate of character for life. In effect, that was a lifelong sentence for a minor charge, and that was very unfair. It was important, in our view, to carve out from offences under the Dangerous Drugs Act that type of offence. So today, a fine of up to 50,000 rupees for the possession of a dangerous drug in a minimal quantity for personal use or for smoking would eventually disappear from the certificate of character after 2 years. Fourthly, sections 16 to 20 of the Cyber Security and Cybercrime Act, for example, misuse of fake profile, cyberbullying, cyber extortion, revenge pornography, and cyber terrorism, have been added to the list. Sections 3 and 4 of the Financial Intelligence and Anti-Money Laundering Act and the Prevention of Corruption Act have been removed, since they have been repealed and replaced since 2023 by the Financial Crimes Act. Accordingly, the relevant sections under the Financial Crimes Commission Act have been added to the list. Sections 58, 59, 64 and 65 of the Representation of the People's Act, that is, illegal payment, corrupt withdrawal of candidature, bribery and treating, and undue influence, which are considered to be serious offences, have been added to the list. Causing death by careless driving when under the influence of alcohol, drug or intoxicating substance, in breach of the new section 123D of the Road Traffic Act, is now considered to be a serious offence, serious enough to be included in that schedule, Madam Speaker. Lastly, all the sections of the Criminal Code have been reviewed. Some have been removed either because they have already been repealed or because considered to be less serious offences given the sentence provided, and some new sections of the Criminal Code have been added. For examples, we have sections 52 to 56, 76A, 85, 87, et j'en passe, which have been removed since they no longer exist, and offences such as enticing away servants, pawnbroking and money lending without a lawful authority, hindering judicial sale, disturbing a religious ceremony, involuntary homicide, winds and blows, taking part in an unlawful assembly, have been removed since they are not as serious as warranting that they remain on that list. Here, Madam Speaker, I must add that amendments will be brought at committee stage to reflect the fact that after careful review, it is now being proposed that some further offences do not deserve to be on the first schedule list of serious offences, while others ought to be included in that list. And last night I have, because of that, circulated to all members of the House a new amended schedule with all the changes tracked so that they can follow what will happen at committee stage on the next occasion. One of the offences which would not remain on that list is, for example, simple larceny, a very common offence which young offenders may commit and whose consequences stay with them for life. At the same time, more serious cases of larceny, such as larceny with violence, larceny by night breaking, will remain on the first schedule. This, Madam Speaker, is a concrete example of the balancing exercise which we are doing here between rehabilitation and keeping society safe. Madam Speaker, the bill also brings consistency between the English and French versions of the certificate itself. A comparative reading of the present forms revealed unnecessary differences and some inaccuracies. There are also discrepancies in the explanatory notes and grammatical and structural defects in the French text. These have all been addressed in the second and third schedules to the bill.
Wow.
The bill also extends the validity of a certificate from 3 months to 4 months. It is a modest amendment, but useful practical improvement. Now, Madam Speaker, before I conclude, I wish to say a word about the suggestion that I've read about in the press, made in some quarters, that there was no need for a new bill and that a few amendments to the existing Act would have sufficed. I do not share that view. The bill before the House runs to nearly 29 pages. The current law is 14 pages long. If we had proceeded by amendment, the amending legislation would itself have been longer and more cumbersome than the Act being amended. Almost every section of the existing law would have had to be amended or repealed. New provisions would have had to be inserted. All 3 schedules would effectively have to be repealed and replaced. At some point, Madam Speaker, one must choose between patchwork and comprehensive legislative drafting. This bill chooses clarity. When a statutory scheme is being substantially reworked, clarity is better served by repeal and replacement than by a long trail of textual surgery. Madam Speaker, this bill has been prepared through close collaboration between my office, the Office of the Director of Public Prosecutions, and the Law Reform Commission. I here place on record my appreciation for their work and their input. The reform before this House, Madam Speaker, today is a practical act, but it is also something more than that. It reflects a view of justice. A view that the law must protect society, certainly, but also a view that the law must leave room for amendment of life, not only amendment of statutes. A fair legal system is one that punishes where punishment is due, but does not continue to punish when the demands of justice have already been met. That, in essence, Madam Speaker, is what this bill seeks to do. And with those words, I commend the bill to the House.
Thank you. It has to be seconded. Thank you, Minister of Agriculture. Maybe it would be wise to break for tea now. Then you can make your speech, Leader of the Opposition.